case anyhow. The reason why I suggested to Francesco Lauro to put the Essence Convention on the agenda today is that the Essence Convention as amended will come into force, at least in the European Union, at the end of next year. It is a long way because the convention was adopted in 1974. It was amended slightly 2 years later just to change the franc poincaré with the, I was going to the French now, with the special drawing right. But then a more substantial change was made in 2002, and the most significant change was the adoption of the compulsory insurance. In any event, 2002, we are near 2012. The protocol of 2002 is not in force yet. The reasons are various, but the main reasons are the increased dimensions of the cruise ships, the number of passengers the ships are carrying on board, and consequently the increase in the limit. Not only that, but in the exception for war risks and war event, which is provided for in Article 3.1a of the Convention, terrorism was not included. That entailed, of course, a big concern in shipping and in insurance markets. It was tried to take care of that omission by IMO in a number of years ago, 2006, when IMO's legal committee adopted a reservation and a series of guidelines. The reservation, I'm going to deal with that later on, but in details. The reservation was adopted, and there was a hope after the adoption of the reservation that the ratification of the protocol would come forward. But that has not been the case. Nothing happened. Nothing happened until the time when the European Community adopted a regulation in which it incorporated the Convention as amended by the protocol, together with the IMO reservation and guidelines. That triggered and will trigger the adoption, by the entry into force, or in any event the adoption of the uniform regime within the European Union by the end of next year. And that is, of course, a change. The reservations adopted by IMO consisted in the limitation for the risks in paragraph 2.2 of the guidelines to change slightly the limit provided for in the convention, because there was not only a limit for the first part of the liability until 250,000 special drawing rights for each passenger, but there was, on the top of that, a cap of 340 million special drawing right on each distinct occasion. Of course, that is a big amount, but if you consider the dimensions of modern cruise ships, in the case of a major disaster, the 250,000 special drawing rights would come up with an enormous amount. Therefore, there was that cap which was adopted by IMO. Not only that, but the insurance, the guidelines that follow, that are part of the reservation, because they are attached to the reservation, provide indication as to the terms of the insurance. First of all, there are two distinct insurances, one for the non-war risk and one for the war risk, which are separate. And the insurance of the war risk has to be made according to certain terms that are accepted in the market today. And some of them, of course, some of those terms are not in line with the provisions of the Essen Convention as originally drafted. So that will create a change significant. But the regulation has a particular importance for this reason, that incorporates the convention within the regulation, except two provisions. The provision on which in Article, I think, 19 and 20, let me see if, on jurisdiction and recognition and judgment. And because provisions along in that area are already adopted within the European Union by the regulation of 2001. Therefore, these two provisions are accepted, but apart from that, all the terms of the Convention have been incorporated in the regulation, and also the IMO reservation and guidelines have been incorporated. But not only that, the guidelines have become compulsory. There is a provision in the regulation to the effect that the word should must be read shall, in order to indicate the binding character of the provision. It is not normal that guidelines acquire the force of law. We have some precedents in IMO because there are other technical or safety provisions that were born as guidelines and have become, by the incorporation into SOLAS, they become binding. But this is done expressly in so many words within the new regulation. Therefore, both the reservation and the guidelines will acquire the force of law. That may create some doubts as to whether the reservation is in line with the terms of the Convention, because the Convention does not provide for any freedom to reserve any right at all. Therefore, it may, from this point of view of international law, be a question whether the reservation is valid. It will be valid if there will not be any objection from the states that are already parties to the Convention. The fact that the reservation has been adopted by IMO probably is a good reason for people to not to raise any objection to this reservation in the future. The regulation provides that it will become effective when it will have been adopted by the states parties to the European Union, or in any event by the end of in 2012. In that case, if the protocol will not have been ratified by the state parties by the end of next year, and in order that the protocol become effective by the end of 2012, it must be ratified by 31st December 2011. Therefore, there is not too much time to go before, because it must be ratified. It must be ratified either by all the state parties, or even though the Convention does not have any express provision in this respect, by the community. It may be, and probably this will be the solution, a ratification by the community itself. But if the convention as amended by the protocol will not come into force by the end of next year, the regulation will come into force by the end of next year. There is a provision to that effect in the last article, I never remember numbers, of the regulation itself. That also will trigger another question. what will be the status of the rules of the Convention if it will come into force within the European Union, but not because the European Union or the countries members of the Union will have ratified it, but only because it has been incorporated in a European regulation. In that case, I submit it will come into force as an internal law of the community, not as an international convention. No, it will come into force in all the member states of the Union, but it will not come into force as a convention, but only, I repeat, as a community law, acquiring the same status than regulation generally. So this is the position, but it is important to consider what will happen. The limits are slightly amended, because first of all, from the interpretation I've tried to give to the provisions of the regulation, it does not appear that the second limit to 400,000 SDRs, which is provided on the top, because we have a first level up to 250,000, in respect of which liability of the carrier is strict. Then we have another layer from 250,000 to 400,000, in respect of which the liability is not strict anymore, and there is even a reversal of the burden of proof. So we will have these two layers, but if one reads the regulation, it seems to me that the second limit, the second layer from 250,000 and 400,000 will not be enforced insofar as the war risks are concerned, only the war risk, because the situation does not change insofar as the non-war risk, but it will change insofar as the war risks are concerned. And another aspect which may create in the future some concern is the fact that there may be a conflict between the regulation and the 1976-1996 Conventional Limitation of Liabilities for Maritime Claims. Because whilst in the Essence Conventions as such, there is a limit per passenger which may be compared with the limit per package or unit of the Hague-Visby rules. Therefore, it is a limit which operates automatically, but there is no global limitation in those conventions. Under the Hague-Visby rules, a ship owner will, of course, it does not need to invoke the limit per package and unit because it applies automatically. The court must apply it. So it is automatic. The global limitation instead operates if the party who can benefit of the limitation will invoke the benefit of a limitation, commence proceedings in accordance with the provision of the Conventions 76-96 at present. Also Italy, regretfully, has not yet become a party to it. Of course, the law authorizing the acceptance of the convention has been now promulgated 1.5 years ago, but the ministers haven't got the time so far to consider that it would be appropriate to prepare the supplementary legislation, the implementing legislation, and therefore the Minister of Foreign Affairs cannot deposit the instrument of acceptance of the convention. So that is the position. But in any event, the cap of 340 million is a cap which is not anymore an automatic limit. See, it is automatic, but it is not a limit which applies to every individual passenger. It is a global limit. And since it is a global limit, what is the relationship of that limit with the limit of the LLMC Convention? That is the problem, that it was easy to solve. I am not a mathematician. I tried hard to find out where the conflict arose. And if somebody who is more expert than me on mathematics will find out that there is a moment in which the number of passengers will be such, passenger injured or dead, that will be such that the limit of the 340 million will overlap the limit of the LLMC, then there will be a problem because the limits will differ. So which one will apply? Probably, if I'm thinking now, I haven't thought about that, but now I'm thinking about this. If the protocol, the convention is amended by the protocol, will come into force as a community legislation, what is the relationship between an international convention and a community legislation? The international convention, particularly if it is precedent to the adoption of the national rules, will prevail. If it had been adopted afterwards, no. But in this case, it has been adopted before, because even the... No, we have a problem, because it is 2002 and 2001, insofar as jurisdiction, etc., are concerned. So there is a problem of the comparison and the priority of either the community legislation or an international convention. But there will be a problem. Let us hope that the problem will never arise, because I hope that there will never be an accident of those dimensions in the future, never. But since people have thought about that in putting up this cap, there is a possibility that a clash will arise in the future. So I think people, or at least lawyers, will have to consider how to solve this problem if it will ever arise. So this is my short presentation of not of the Essen Convention, because I have not discussed the terms of the convention, of the future at the end of next year. And then we will have the time during the next year to consider in details the terms of the convention and see if we can understand it properly. Thank you very much.
Thank you very much, Professor Berlingieri. You made easy, even difficult juridical points, and I thank you very much for that, since really it was quite a speech, and personally I appreciated it very much, and I think all the audience has appreciated the clear and simple way you did it. Thank you.